pause and think about your overall retirement savings. What percentage of your account is in a 401k or qualified employer plan? Chances are quite a bit of it. With 60 million people saving in a 401k these days, it has quickly become the go-to place for Americans to store their wealth. Yet one tiny mistake can completely blow all of your planning: the beneficiary. Qualified plans like 401ks are governed by federal law, which means there are very rigid rules in place for what happens to your account when you die. Federal law mandates that your legal spouse is entitled to inherit all of the money unless they sign a written waiver saying that you can name a different beneficiary. Now, for many people, this is not an issue, but there can be a number of reasons why you wouldn't want your legal spouse to inherit your 401k. Maybe you've done some aggressive estate planning and you've decided it should go to a trust. Or from a tax planning perspective, you've determined it would be better for your children to directly inherit the account. Or maybe you just don't like your spouse. Bottom line is, legally married, happy or not, your spouse will inherit your 401k without a signed waiver. Moving on. In the amount of time it takes to complete a romantic comedy, 2 hours, about 176 divorces will occur. If you have named your spouse the beneficiary and do not change that, they will still inherit the retirement account. It's shocking, I know, but a named beneficiary almost always trumps any other legal documents. This includes your will, a fancy estate plan, and yes, even a divorce decree. Take the case of Holmes versus Kent from Texas in 1997. A teacher divorced her husband and specifically included in the divorce decree that he would waive his rights to her retirement account. She attempted to change the beneficiary, but never actually completed it, and unfortunately passed away 1 year later. And despite the fact that she clearly bequeathed all of her assets to her son and all of her legal documents, the court ruled that the retirement assets would still be distributed to her ex-husband because she never actually changed the named beneficiary. Let's add another layer of legal complexity: children and a split household. Here's a sample story to illustrate how quickly your ultimate wishes can fall apart. Let's assume you remarry and each spouse brings children into the marriage from a prior marriage. And we're going to go a little dark here, but we have to. Let's assume they're in a terrible car accident. The wife passes away unexpectedly and immediately, and a day later, her husband passes away. In this scenario, the wife's 401k would, by law, go to her husband. Upon his death, it would be distributed according to either the state's intestate laws or his will, which would most likely be a distribution of his assets to his children. Without proper planning, she has unintentionally disinherited her own children. Now, let me reiterate one more time that this law trumps a prenuptial agreement. If you are remarried, you must complete estate planning and update the beneficiaries named on your 401k to reflect that planning. If you are not married and you do not name a beneficiary, your assets would likely follow intestate succession. Typically, your children would inherit first, then your grandchildren, then your parents and siblings, and followed finally by aunts and uncles. Now, one final note, these rigid rules apply to qualified employer-sponsored plans governed by federal law. IRAs are governed by state law and do not have to have a spousal waiver to change the beneficiary of an IRA. However, if you live in a community property state, your accounts will fall under those laws. Now, I will emphasize one more time, this is an area, especially the more complexity that you have, you need to engage an attorney and speak with an estate attorney. But what I can tell you is all of that planning will be for naught if you don't update the the named beneficiary on your account. That's it for this week. This is Jeannie, the 401k lady.